Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Richard B. Horfinger, Judge, presiding. All persons having business before the court draw near to attention and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. As the Marshal indicated, I'm Judge Orfinger, and I'm joined on the panel today by Judge Meredith Sasso on my right. And we're pleased to have an associate judge with us, Judge Anthony Taddy of the 5th Circuit, joining us on the panel today. Everyone has 20 minutes to make their argument. The appellant can reserve as much time as he or she chooses. We have, the second case has a cross appeal. So basically we'll go appellant, appellee, cross appellant, reply, and then back to the appellant for their reply to the cross appeal. And you'll be also able to reserve as much time as you want for your reply. Let me get my glasses so I can actually see the docket. Our first case this morning is State Farm versus SZAFRAN, and I hope I'm pronouncing that correctly. So, without any further ado, let's get started. Oh, if you have a cell phone with you, please silence it. Thank you very much. All right, let's proceed.
May it please the court, my name is Rhonda Bogus. I represent the appellant, State Farm Mutual Automobile Insurance Company, in this matter, and would like to reserve 5 minutes for rebuttal.
All right.
State Farm is seeking a new trial on this judgment entered on an uninsured motorist action for several reasons, but the common thread of all of them is that there was a limited parameter of the trial, an artificial universe. And then the trial that took place was not within those parameters as set by the court and by the parties, resulting in an unfair trial, and a trial in which State Farm was deprived of the opportunity to present evidence in its case, really, that was dealing with the issues before the court. Excuse me. There was a second, this was an automobile accident in 2011. There was a second accident in 2016, which was more severe. It was a front-end collision. The accident in question was a rear end. And so State Farm sought a continuance because it wasn't able to get all the records prior to the trial. It was a very lately disclosed accident. And the parties ultimately had agreed that, okay, the plaintiff will drop future damages, and we're going to limit the trial to this 3-year period. And the specific request was, okay, fine, that's fine if we limit it to that area, and that State Farm's counsel specifically said, if you open the door, we've got a problem because we don't have the records to provide to our experts. Our experts have not seen her after the accident. State Farm's experts saw her like 6 months before the 2016 accident. So the trial begins, and
let's talk about, I know that the doors opened and that State Farm did get to do a limited, at least, cross-examination mentioning the second accident. And as you've noted in your brief, the standard here is abuse of discretion. So how would we, sitting as an appellate court, say that the trial court abused its discretion in either not granting a new trial or not granting any additional relief based on the cross-examination that State Farm was able to get in during the trial?
Correct, Your Honor. State Farm was able to cross-examine based upon just trial counsel's knowledge of the difference in front and rear end collisions and to cross-examine. But there's no debate, and plaintiff does not debate, that State Farm had no direct evidence. It had no witness to address, it had no expert to address the 2016 accident. Excuse me?
You had pictures you tried to introduce.
We did, and in fact, the court, again, even though the door was open, and the court ruled specifically twice the door was open.
Who opened the door?
Plaintiff's expert opened the door, and that is clear. Plaintiff's expert, Dr. Oppenheimer. In fact, plaintiff's attorney basically on page 96 of the trial transcript said, we have a significant issue now, it seems. We agree. There was a significant issue, and at that point, State Farm's motion for mistrial should have been granted.
Well, why did the question that you reference in your brief, why did that open the door?
Well, the question...
Dr. Oppenheimer began his testimony by advising the jury that he had examined Ms. SZAFRAN, right?
Yes, ma'am. Yes, sir.
And that was what his job was to
Right.
assess the extent of her injuries from 2011.
Correct.
So he saw her, obviously, after 2011.
He actually saw her after the 2016 accident in 2017.
But he didn't say anything about the
Right.
2016 accident, did he?
Well, here's the statement that the trial judge ruled opened the door. And in fact, that was not cross-appealed. I think after I saw her, this is 2017, and reviewed the records, my impression was the back surgery was not as successful. She had significant pain in her left leg. And in fact, this was kind of State Farm's counsel actually anticipated this. They said, look, if she stands up and talks about her pain at this point, we're going to argue to Your Honor that they've opened the door. And the court said, we'll deal with that later. So the court ruled that it had been opened. That was not cross-appealed. He ruled it twice, I think on 95 and then again on 102. And there really wasn't a debate by plaintiff's counsel that he did rely upon the examination and the complaints made by the plaintiff in the 2017 examination. And in fact, the plaintiff's counsel basically said, look, he was confused. We were trying to talk to him about her pain complaints back at that point. He answered on the pain complaints at that time. So there's really, that's a red herring in the brief. They didn't argue at trial that this was improper, that it was not open the door, and they didn't cross-appeal that. And the trial court held specifically twice it opened the door, yet State Farm was limited to cross-examination on closing.
By the judge?
Well, and by the part that they did not have the evidence, which everybody agreed. And if you look at the pleadings and the motions that were in relation to the motion for continuance and the admissions made by plaintiff, everybody agreed that State Farm did not have all of the records. It didn't have some of the diagnostics. It did not have, there's no debate that State Farm's only expert saw her before the 2016 accident. In fact, he testified at trial that he didn't even know about the 2016 accident. So, they went into this trial thinking this is what's going to happen, and plaintiff's expert talked about, based his permanency opinion, and again, $500,000 of this verdict was based upon intangible damages, which required a finding of permanency. And the sole expert as to the issue of permanency based his opinion on her condition in 2017. And he even admitted in cross-examination that if he had been provided with 2016 accidents, records, because again, he didn't have to look at those records either.
It's not something that State Farm could have anticipated, because am I correct that when the issue came up of whether when State Farm moved for a continuance based on the discovery of this second accident, that it was agreed that if the plaintiff withdrew claims for future damages, that State Farm would basically withdraw the request for the continuance. And at that time, State Farm could have anticipated that the permanency issue would be the primary focus of the case, and still did not request a continuance in light of that before the trial.
At the time of the agreement, and this is actually in the record on 4993, and this is the representation made to, and in fact, the trial court was the one who suggested that they withdraw the future damages and go forward, because he didn't want to continue it either. And he said, anything after 2016 or the date of the action would be considered future, and there won't be any testimony or evidence. For example, she got on the stand and said, this is what my current pain symptoms are. And if so, we would need the records to impeach her and talk about the second accident. So State Farm was holding plaintiff to the concept that they were going to be able to present a case limited. And I think you could even say from the plaintiff's surprise that we have a significant issue, that they anticipated that they would be able to provide, to do that, but they were not able to do so. And then once the door was open, plaintiff's counsel on direct examination asked her about the 2016 accident. You've got a situation where State Farm's counsel is arguing in closing, using your common sense, jury, the forces and impact of a front-end severe accident are different than the forces and impact of a very minor rear-end accident.
Doesn't that go to, when you talk about a motion for new trial and whether it's so unfair that it would vitiate the entire trial, State Farm was able to cross-examine the plaintiff on the second accident. They were able to argue to the jury to use their common sense, to look at the pictures and that sort of thing. So how does this take it to the level that it's so unfair that the trial court acted completely unreasonably in denying a motion for new trial?
Well, for two things. One, State Farm had no direct evidence. It did not have the opportunity to hire a biomechanical analysis of the difference between the two. It had no doctor to discuss, an expert witness to discuss the differences in the impact in the first accident and the second, and which one would give rise to pain complaints. It had no opportunity to review the medical records and provide a full analysis to the jury. Not only that, but we've cited in the brief, there is a plethora of cases that says it is for the jury to make that determination. When you have two accidents and you're seeking damages and injuries that basically occur in both accidents, it's for the jury to make that determination. And the jury is supposed to be, and the case law is clear, that it is error to not allow the second accident to come in and evidence as to the second accident. And I would submit to the court that having to cross-examine on the fly with limited records is not what is supposed to happen in a trial. If the plaintiff puts on evidence, which they did, their case relied upon her condition in 2017, then State Farm was entitled to put on its own evidence, develop its own case in chief, and not be playing catch-up when it was violated. Similarly, and the same kind of argument happened with the whole mental anguish issue. I mean, it was withdrawn. It was clearly withdrawn, and when it was withdrawn, she had testified that she had some depression and some other psychiatric issues. State Farm had done a notice non seeking those records. They withdrew the mental anguish.
So, and I understand from the brief that you cite several points where it says, she was in a dark place and she was grumpy. Couldn't the jury reasonably infer that that was from continued pain, and wasn't the plaintiff's theme throughout this case, through opening and closing, that it was just 3 years of constant pain and headaches and that sort of thing that would make her want to stay in the dark place?
If they had limited to just pain, this court has held that physical pain in and of itself does not give rise to mental anguish. But you're talking about the theory of the plaintiff's case. I would submit, look at page 162 of the transcript. According to the plaintiff, quote, "Our whole theory is that she's an eggshell plaintiff. She has all these other ailments, but she has never got down until this accident happened, and she had a very dark 3 years." That's not pain. That is a mental condition. Their fourth motion in limine, which was granted, and it was granted regardless of what they say, basically was on a mental state. Their motion for limine was to preclude State Farm from addressing her mental state. That was the word used. That's on 2033. But then their whole theme of the case was that for 3 years she had a hopelessness, that she was sad, she was in a dark place. Depression.
Didn't they call it loss of enjoyment of life?
If she had phrased, and she did have some evidence of loss of enjoyment in life, and relating to the pain caused her to not want to crochet, and the pain caused her not to do things with her kids. But when you're talking about, when you're using your emotional state and your emotional condition, or your mental state of being sad and in a dark place and hopelessness, and this was admittedly their theme, and it gave rise to $500,000.
Is it your position that loss of enjoyment of life can never include a discussion of the emotions associated with pain? That automatically converts it to mental anguish.
I think there can't be a bright line in turning on when loss of enjoyment of life. If it relates to physical pain, which they were. I'm not saying this very well. Physical pain in and of itself can give rise to a loss of enjoyment of life. And if they had limited to that, and the fact that she wasn't able to do these things, and that was terrible, that she was deprived of the enjoyment of doing those things due to the physical pain, then that would fall within the parameters. But what they did was really divorced from the pain. The testimony that she gave, they can say it had to do with loss of enjoyment, really wasn't connected to the pain. It was the fact that she was in a dark place. She was grumpy. She didn't want to be with anybody. She was hopeless. Hopeless is not having anything to do with physical pain. That's
Does
a
it have
mental
to do
state.
with a mental or emotional condition necessarily, though?
I would submit it absolutely does. And in fact, the descriptions that she gave are strikingly similar to the defined definition of depression, which we know she actually had. But yet,
Did not put depression or a mental condition at issue, correct? She didn't ask for any sort of compensation for medications or emotional treatment or psychiatric treatment or anything?
well, I would submit she did, because that was the loss, that was her, quote, loss of enjoyment of life, that's what she couched it as, and that's what the trial court held that she was doing.
Well, we're looking at this again from an abuse of discretion standpoint, and we would have to say that the trial court acted as no reasonable judge would. Wouldn't it be reasonable for the trial court to determine at this point that she was not talking about a mental condition, she was talking about she couldn't play with her grandkids, she was in pain, she couldn't crochet, she couldn't do this and that and that, and all these things, all these activities that are loss of enjoyment of life, and that these references to, falling down, for example, is just another example of an egg finally breaking rather than some sort of mental condition that would be more properly characterized as mental anguish.
I do think it's an abuse of discretion when only one side is allowed to present evidence on the same issue. And in this case, it was her emotional state, her mental state of being a sad, dark, hopeless place. Yet State Farm could not counter, even with cross-examination, any questions to her because they were bound by the order in limine. And they told the judge that they believed that this was mental anguish, that they believed that the plaintiff again was violating her agreement as to what was going to be litigated, and the trial court disagreed. So again, it's an uneven trial. If she can stand up and talk about her mental condition, but State Farm can't address that mental condition, that is an unfair trial. And that is one in which, again, particularly when combined with the whole issue of not being able to deal with the 2016.
What about the fact that the real focus of State Farm's argument was permanency? So State Farm, and it may be your position because it didn't have the evidence, but State Farm really didn't focus, it didn't appear to at least to focus on whether or not she was actually upset, whether or not there was other causes. It was whether this accident could cause a permanent injury. So with that being the focus of State Farm's defense, how would this be so unfair as to?
Because State Farm did not have those records. State Farm could not say what the cause of her being upset was, what the cause of her being sad and hopeless was, because State Farm, understanding that she was entitled to keep her mental state private and not anticipating that she would in fact only use it to her benefit, did not have those records. They could not counter her assertion that because of this accident she was in a dark place for 3 years. They couldn't counter that because they didn't have the records due to the withdrawing of the mental anguish and then also in the order in limine. So what are they going to do? And they asked to address the depression, and the court said no. I think it's loss of enjoyment. So the limited information they had from the plaintiff's deposition, they were not able to use. And I'm going to reserve the remaining time for rebuttal. Thank you.
Thank you, counsel.
Good morning. May it please the court. My name is Brent Steinberg. I'm with the law firm of Swope Dante, and we have the privilege of representing the appellee in this matter, who is the plaintiff below, Veronica SZAFRAN. Your Honors, it has been 8 years and 3 days since the automobile accident, which brings us here today. Ms. SZAFRAN was rear-ended by a school bus, which was an uninsured motorist.
Could you discuss the argument that the plaintiff's theme below was an emotional condition, mental condition sort of theme?
Well, I don't believe that that's accurate if you look at the entire record. So I guess, yes, let me turn first to the second issue, which appellant counsel discussed on the mental anguish. And first, let me just make this clear, that the plaintiff did not seek any damages for mental anguish, and the jury didn't award any damages for mental anguish. Mental anguish is more than just being sad or upset about something. It's the emotion plus a physical or cognitive change that significantly affects one's ability to function.
And what's your
like-
authority
like
for that
depression.
conclusion?
Well, the case law makes clear that there's a difference between mental anguish and the loss of the capacity for the enjoyment of life. Where this issue has come up before is on the issue of whether or not the psychotherapist patient privilege has been waived.
And aren't those cases, though, at the discovery phase? So, by withdrawing a claim for mental anguish, the defendant wouldn't be entitled to get those records. But here we're talking about whether the evidence was, in fact, mental anguish evidence or whether it was loss of enjoyment of life evidence.
Well, you're correct, Your Honor, that the cases on this issue are addressing it in the discovery realm, but the rationale carries over too. So if it's a claim for mental anguish, meaning the depressive disorder, which seriously affects one's ability to function, then the psychotherapist patient privilege has been waived, and then the mental condition is at issue, and the records would be discoverable and presumably admissible at trial. But when it's just a claim for loss of the capacity for the enjoyment of life, then the psychiatric records are not discoverable. The patient privilege hasn't been waived. We cited multiple cases, and I think State Farm agrees with us on this point. One of the cases we cited was Bigsby versus Reyes, a 14th
And I think they
case.
do agree with you on that point, and they did it at the trial level as well. I think the rub here is that they're saying that although they agreed not to submit mental anguish evidence, they did in fact submit mental anguish evidence. And so that's what I'm trying to understand is where are you getting the authority that mental anguish can include, these basically symptoms of depression, but not actually the condition of depression.
Well, Your Honor, I think the issue isn't whether or not the plaintiff's testimony could be relevant to a claim of mental anguish, but rather whether or not it could be relevant to a claim of loss of the capacity for the enjoyment of life. So let's just focus on what the actual evidence was that was presented at trial on the plaintiff's emotional or mental state. The only thing the plaintiff said was that she had lost joy and hopefulness as a result of the wreck. But this testimony was in the context of the hobbies that she had prior to the wreck that she didn't have, that she couldn't do. She couldn't engage in the same activities after the wreck. Now, State Farm objected, saying that went to mental anguish. But the trial court held that it was admissible because it went to the loss of capacity for the enjoyment of life. And then the plaintiff continued on that her grandchildren viewed her as grumpy grandma during the 3 years after the wreck because she was in constant pain, and she was often isolated because she was in pain. But that's it. That is all the evidence there was in the entire case about, or that even touched on, plaintiff's mental or emotional state. So it wasn't an overarching theme of the case.
What about the testimony, not the testimony, but the argument made about the plaintiff being in a dark place? I mean, how do you distinguish, if you can, between I'm in a dark place because I'm in pain, or I'm in a dark place because I'm depressed, or I'm depressed because I'm in pain?
Well, I think there are a couple ways you could look at the dark place comment, which happened during opening and wasn't objected to, so that's an error that isn't preserved. But the dark place, there was evidence that she had migraines after the wreck and caused from the wreck. She had migraines before, but her headaches got worse after the wreck. So, I mean, I guess there's one way to look at it. The dark place could be in the metaphorical sense for depression, but it also could mean literally she had to be in a dark place, a dark room, because she had migraines. But again, there was no contemporaneous objection during the opening statement or a motion for mistrial.
It was a violation of the motion in limine, though, correct?
No, Your Honor, I don't believe it is. And so on this motion in limine issue, let me address that. So the motion in limine, when it came up, the plaintiff's counsel was explaining that they were concerned that State Farm might have mental health records in their possession because there were some subpoenas that were issued or that we believe were about to be issued before the mental anguish claim was withdrawn. And the plaintiff wasn't sure whether or not State Farm had any of the mental anguish, or excuse me, the psychotherapist records in their possession. So at the hearing, they explained that they just didn't want that evidence coming in if State Farm already had it in its possession. And State Farm said that they agreed with the plaintiff that that wasn't going to be admissible unless the plaintiff opened the door, and then counsel said that they believed that plaintiff would open the door if she testified that she had anxiety or some similar
And it was
symptom.
broader than mental condition, though, wasn't it? Anxiety or some other kind of similar symptoms as a result of the accident. Isn't that what was discussed in the motion in limine that would not be discussed at trial?
That was what State Farm said that they agreed would, or what they said would open the door. So
And plaintiff's counsel advised that will not be presented. And then the court granted the motion to the extent that it was moved for, which is what State Farm had just discussed, anxiety or some other kind of similar symptom.
well, there was no evidence about anxiety or some similar symptom at trial. The
Being in
only
a dark
evidence.
place to the extent it's like Chinese water torture and a grumpy grandma to the extent you can't play with your grandchildren for 3 years as an anxiety or some other similar symptom.
The Chinese water torture comment was the only objection which was raised during the opening statement, and that was in reference to the pain that she was suffering. That was totally unconnected to anything about the mental anguish, and it was sustained as argumentative, but then they didn't request a mistrial or anything, or curative or anything like that. The thing is, so the problem for State Farm is that they never argued that the door had been opened to the plaintiff's mental health records at trial. The trial court also didn't preclude them from offering any evidence about the plaintiff's mental state. And this court's decision in Powell versus State, which State Farm cited in its reply brief.
Didn't the trial court say that the door had not been opened because it went to loss and enjoyment of life? So it was broader again than just the records. They couldn't even cross-examine, for instance, on the testimony that they had in her deposition regarding her depression and suicidal thoughts and her previous prescription or her previous treatment, because the court said that's not mental anguish, it's not a mental condition, it goes to loss of enjoyment of life.
Your Honor, the court ruled that the testimony was admissible because it went to the loss of the capacity for the enjoyment of life, but it never was asked to rule whether or not the door had been opened to anything about plaintiff's mental condition. The trial judge was never precluded State Farm from offering any evidence about the plaintiff's mental state. And in this court's decision in Powell versus State,
So, I just want to make sure I have this clear. On page 6060 of the record, defense counsel says they opened the door, and the court says, as far as it's going to loss of enjoyment of life, I think it's okay, but be careful. Didn't they argue at that point that the door had been opened to discussion of her mental condition and mental state?
Well, Your Honor, I'm turning to page, you said 6060?
Yes.
I mean, I believe that what Your Honor said was accurate, and that is consistent with my memory of what occurred. But this was during direct examination. What State Farm was arguing was that they shouldn't have been allowed, that Ms. SZAFRAN shouldn't have been allowed to say that she had lost joy, and the court ruled that that was okay because it went to the issue of loss of the capacity for the enjoyment of life. And then he was saying to plaintiff's counsel, be careful, and then plaintiff's counsel moved on. This court's decision in Powell versus State, which Judge Orfinger, you were on the panel, this is a 2012 case, and this is cited by State Farm in their reply brief. It says, if the evidence introduced at trial materially differs from the pretrial representations relevant to an issue addressed in the motion in limine, we believe it to be incumbent upon the objecting party to revisit the issue in light of the changed circumstances. You're supposed to give the trial court a fair chance to evaluate the issue. And respectfully, Your Honor, State Farm didn't do that. They never asked the court to revisit any ruling in the motion in limine. They didn't proffer anything about plaintiff's mental or emotional state. They didn't ask the court to compel or admit any psychiatric records. They didn't argue that the plaintiff waived her psychotherapist privilege. They didn't even cross-examine the plaintiff about her mental condition or the fact that she was sad, and it also wasn't any part of the closing that State Farm gave. So State Farm's argument about the mental health records being unavailable wasn't preserved for appeal, and even if it was, the court clearly acted within its discretion when denying State Farm's motion for new trial.
Counsel, let me shift gears for a minute. Let's talk about Dr. Oppenheimer. So apparently, he was the only expert on permanency, is that right?
For the plaintiff, correct.
And although he was aware of the 2016 accident when he examined her in 17, he didn't have any of the records. Is that correct?
I don't know that he had. I don't know whether or not he had any records. He certainly didn't have all of them. I agree with you there. So, but yeah, let's talk about the 2016 accident. And
Well, wait, hold on a minute.
I'm sorry.
So, I guess my concern is, because the defendant didn't have any of the records from the 2016 accident. I mean, they knew there was an accident because she disclosed it in the update depot, but they weren't able to discover it. I don't know why. You guys, you said the case went on for 8 years. I don't know if that was your side's fault, their side's fault, or usually it's everybody's fault. And I understand why the trial judge wanted to get the case to trial and not continue it after 8 years. But nonetheless, why wasn't it relevant if their argument was you didn't have a permanent injury in this minor accident, but you had this major accident subsequent and you complain of pain, why isn't that relevant evidence that should have been discoverable?
The plaintiff was only seeking damages for a limited time period of 2011 through November of 2014. So our wreck happens in October 2011. The plaintiff had a neck surgery in 2013 and a back surgery in 2014. And the plaintiff and her husband admitted that by November 2014, she was essentially back to normal. So this isn't a case where...
But she tells Dr. Oppenheimer she's symptomatic in 2017 when he examines her. She has, let me see what my notes say here. She didn't report that she'd injured her neck and low back in the second accident, but she did complain of neck, back, left leg pain and tingling in both hands after the accident. How is the doctor, if he doesn't have any of that information, how is he supposed to say, well, this is obviously attributable to the earlier accident and not to the subsequent one? Maybe if he had the records, he could make an informed judgment. But he has to take her at her word when she says, I got this, that, and the other. Wasn't State Farm at a significant disadvantage by their inability to obtain records and cross-examine your expert on permanency? Their argument was going to be, well, we didn't cause this at all, or we didn't cause much of it. It was all caused by the second accident. Now, whether that would have carried the day or not, we don't know.
Your Honor, the plaintiff could have been rendered a quadriplegic in the 2016 accident, but that wouldn't affect whether or not she'd suffered damages between 2011 and 2014.
But the doctor didn't know in 2016, in 2017, if she walked into his office and said, if she was a quadriplegic, she wouldn't have walked into his office. But if she was a quadriplegic in 2017 and said, I'm a quadriplegic and I had an accident in 2000 and whenever the first one was, 2008 or 9. If she doesn't ever disclose any information about the second accident, he doesn't know if the quadriplegia was caused by the first accident or the second accident. He only sees her in the condition that she's in 2017.
I don't think it was any secret that there was a subsequent accident in 2017. It was just the doctor wasn't focusing on that or her condition in 2017 because it wasn't relevant to his opinion whether or not she'd sustained a permanent injury years earlier in 2011.
Look, it seems like you all were trying to thread a needle here, and the question is, did you thread it or did you miss it? And did it ultimately affect the fairness of the trial? And help me understand why it wasn't important for the jury to hear and for State Farm to be able to make the argument, we didn't cause this was all the second or mostly the second accident.
Because the focus of the entire case was during the 3-year time period between October 2011 to November 13th, 2014. So what State Farm's arguing is that they were prejudiced by not getting more evidence regarding the 2016 accident, that they should have been allowed medical experts, biomechanical engineers, et cetera. But if the case was retried tomorrow, none of that evidence would come in because the focus of the entire case was on the 2011 to 2014 time period.
What if those records said something like, so-and-so presents today following the second accident. They've never had any complaints of neck or back pain up until this accident. Would that be relevant to the first accident?
Well, Your Honor, the records don't say that. I suppose.
State Farm doesn't know because they didn't have the records.
I mean, it was undisputed by anyone that the plaintiff had, it was State Farm's position that there was a temporary exacerbation of a pre-existing chronic condition. But, I mean, State Farm acknowledges that the plaintiff was injured in the 2011 accident. They're just taking the position that it wasn't a permanent injury. But what Dr. Oppenheimer opined, if you look back at the testimony, was that the 2011 crash caused the plaintiff to suffer a herniated disc in her neck, and that it permanently exacerbated a pre-existing herniation in her lower back. He opined that the discs were permanently altered and that the plaintiff eventually required surgery to alleviate those symptoms. And because there was a permanent anatomical change to the plaintiff's body, that meant that there was a permanent injury. That was Dr. Oppenheimer's testimony. And now that was mainly based on his review of the MRI films and the medical records from the 2011 to 2014 timeframe. He wasn't really focused on anything that happened after 2014. Now, when he saw the plaintiff in April 2017, he did take an extensive medical history from her, and he testified that part of his opinion on permanency was based on that medical history. But, Your Honors, to me, it's not clear from the record exactly what he's talking about, because there's two ways that you can look at his testimony. On the one hand, you could take State Farm's position, and you could say that when he's saying that he was relying upon the medical history, that he must have meant that he was relying upon the plaintiff's description of her ongoing symptoms when he saw her in 2017. On the other hand, the other view of the testimony, which is the one that we believe to be more correct, considering all of his testimony in the totality, was that he was relying upon the medical history which he took from the plaintiff in 2017, but was discussing things that had occurred years earlier. Because he said that her condition in 2017 really wasn't his focus in regards to permanency. So when the door has been opened, the party may introduce otherwise inadmissible testimony for the purpose of explaining or qualifying or limiting the testimony which opened the door. And State Farm did that. If it was State Farm's argument, and they tried to weaken Dr. Oppenheimer's opinion on permanency by saying, well, isn't it true, doctor, that there was a 2016 accident? So they were allowed to do that. What the trial judge did was he did a 403 analysis in ruling that it would put too much emphasis on this subsequent second accident, which had nothing to do with the damages that the plaintiff was seeking. He did a 403 analysis to determine that the property damage photos would put too much emphasis on the subsequent accident. And respectfully, Your Honors, State Farm hasn't demonstrated that there was an abuse of discretion in that ruling, or that the trial court abuses discretion in failing to grant the motion for mistrial. The whole focus of State Farm's argument was they wanted evidence of this 2016 accident. If you go back and you look, you'll see that although the judge ruled that the door had been opened during the plaintiff's direct examination, this was State Farm trying to get the evidence about the 2016 accident in. And the purpose was they were trying to say, look how much more severe the 2016 accident was than the 2011 accident as a try to minimize the 2011 accident. But the invited error doctrine should stop State Farm from complaining about the fact that evidence came in. The fact that they interjected the issue of the 2016 accident into the case means that they can't complain about it now that it didn't work out the way that they'd intended. I see that my time's almost up, Your Honors. Are there any additional questions? So in conclusion, I would just say that State Farm has a heavy burden here. They have a heavy burden to demonstrate that the trial court abuses discretion in denying State Farm's motions for mistrial, new trial, and remitted her. They haven't met that burden, and on that basis, we would respectfully request that this court affirm.
Thank you, counsel.
May it please the court. To follow up what Judge Orfinger said, in fact, Dr. Oppenheimer, who was the only expert who opined that she had a permanent injury from the 2011 accident, said that his opinion that she had a permanent injury was based in part on the symptoms she told him he had in April 3rd, 2017. And he would agree that if she had in fact had hurt her neck and back in the 2016 accident, which presumably medical records from which she received care for the 2016 accident after being taken by ambulance away from an accident in which the car was totaled, would address those issues as to whether she had neck and back pain, that his opinion might be called into question. I'm hearing from plaintiff's counsel that, oh, State Farm did a good job on cross-examination, and that's all to the credit of defense counsel. But defense counsel didn't have the medical records to cross-examine Dr. Oppenheimer with. They only had some. They didn't have the diagnostic. And they didn't have the records to provide to their expert. Their expert had not seen her after the accident, nor had he reviewed medical records afterwards. And the plethora of cases make it very clear that when you have injury to the same part of the body, the neck and back, for 2 successive accidents, and you're suing one tortfeasor, that successive accident is in fact relevant. It also was clear that the photos of those evidence of the accident which show the impact are relevant. They are important for the jury to make that determination, and that it is error to not allow the jury the opportunity to see the true universe and facts and not this artificially limited, inappropriate recitation that was done by plaintiff's counsel in this case. As to the mental anguish, I find the argument that this wasn't mental anguish because there wasn't any evidence that it caused her to have some change in her ability to function or anything. Well, yeah, and that's coming from the DSM. We don't know that because we don't have the psychiatric records to see if, in fact, presumably, the doctor who diagnosed her with depression did, in fact, make that finding. It cannot be the argument, it cannot be the rule that it is not mental anguish damages unless you stand up and go through the DSM-4 or 6 and go through every single symptom. In this case, the motion in limine clearly was mental state. And, in fact, this court and some of the cases have talked about when you're talking about introducing an emotional condition, that is in fact the exception to the psychiatric privilege. As to the preservation issue, specifically when she testified, I just lost all joy, just hopelessness, nobody wanted to be around me. Defense counsel immediately advised the court that that testimony was in fact mental anguish damage. Again, this was mental anguish damage that plaintiff had withdrawn and said she was withdrawing and said was not going to be part of her case. The trial court disagreed. This was preserved. State Farm, in fact, State Farm also told the judge, Your Honor, she's got depression, she's on medication. We can't combat what she's testifying to with the limited information we have, and that they've opened the door by their theme of being in a dark place for 3 years. And the court disagreed. So for all those reasons, as well as additional ones in there, this was a trial in which the plaintiff had the advantages and State Farm was not allowed to have the evidence to combat it, and we'd request a new trial be granted. Thank you.
Thank you, counsel.